Good morning and welcome to today's program, Defense Contracting Updates to the FARS and DFARS. This event is brought to you by the Pacific Northwest Defense Coalition and Davis Wright Tremaine. First, I wanted to confirm that everybody can hear us okay here. If you could just type yes in the question tab if you can hear okay and see the screen, I would appreciate it. Great. Wonderful. Thank you so much. Feel free to ask a question using the same question time at any time during the broadcast. Just type your question in that field and we will be able to read that to the speakers. Also available on the right-hand dashboard for GoToWebinar is a Handouts tab. You'll see a copy of today's presentation there for your download, as well as a list of upcoming PNDC events. I'd like to introduce our speakers now. We are very pleased to have Jonathan DeMella and Kate Kennedy with Davis Wright and Tremaine on the line today. Both of them focus their practice in government contracting, counseling, and litigation, among other pursuits. And they are going to be able to share with us quite a bit about updates over the last year in government contracting, particularly to the FARS and DFARS. In the interest of time, because there is lots to cover today, I'm going to turn things over to Kate and John and let them begin their presentation.
Thank you, Kate. Good morning, everyone. This is January 22nd. It's day 3 of the shutdown, although I have just learned from a colleague in the room here that that may now be ended. Nevertheless, if there are, I should say, if there are any questions on that, we can reserve till the end. But let's get started, and we'll just go right to the first slide. So, in the spirit of professional and academic inquiry, we're going to keep this as a nonpartisan discussion. Nevertheless, because it's pertinent, President Trump, we're going to start with one of his tweets over the weekend, and it bears directly upon the discussion that we're going to be having today. And you'll see that he says that he has terminated more unnecessary regulation in the last 12 months than any other administration has terminated in their full term in office. Now, I don't know whether that is true or not, but what I do know to be the case is that this particular administration has made it clear, and we can go to the next slide, that there will be no new regulations without very specific hurdles that are overcome by federal agencies. And to that point, the FAR has not seen any change, well, I should say any update. There has not been a new word, a new syllable added to the FAR since this inauguration, since this administration came into office. The only change that we have seen has been to FAR part or subpart 22.2, which was the removal of the Fair Pay and Safe Workplaces Act. And you may remember that that was the act that required COs to make pre-award responsibility determinations with respect to contractors' compliance with labor laws, and that contractors and federal contractors and subcontractors in the submission of proposals were required to disclose whether there had been any labor law violations. So that provision as of November 6th is out of the FAR, and that in essence has been the only change. Now, I should say that despite the fact that we haven't seen changes to the FAR, Kate and I have much to talk about. We will be discussing certainly the executive orders that are behind that particular policy, but also a variety of cases in the pre- and the post-award period, as well as some other interesting cases that I think really highlight some of the significant changes over the course of the year. As far as this particular executive order is concerned that we have on this slide, 13771, You may recall that right at the start in January, President Trump indicated that for every one regulation issued, at least 2 prior regulations must be identified for elimination. And perhaps more significant than that, that the incremental cost associated with any new regulation has to be offset by the elimination of existing costs associated with the new and the old, the elimination of the old regulation. Now, this is something that I can't imagine is a particularly easy task. And if we go to the next slide, you'll see that on the follow-up executive order, 13777, this was the executive order that was issued on February 24th. He empowered agencies through regulatory reform officers as well as task forces to really work on this problem. The issue is, obviously, over this last 11, 12-month period, that the agencies have not really yet been able to figure it out. So what we can expect to happen in the very, I don't know when it's going to be, but I think it's going to be at some point this year, is a massive federal acquisition circular. These are the circulars that are issued by the FAR and the DFAR Council that will identify new regulations that go into the acquisition regulation. And I imagine that the agencies that are grappling with this are working on this right now. I know that even prior to President Trump taking office, there were initiatives by GSA and the VA to look at things like the 50 worst regulations and try to improve them, all in the furtherance of acquisition streamlining. But ultimately, this is something that those particular changes are something that I think our federal government is just going to unload all at once, and we're going to, as lawyers, as contracting professionals, we're going to have to deal with a lot of change all at once. One other point on this slide that I'd like to draw your attention to is the open FAR cases. There are a listing of open cases. These are proposed changes to the FAR that the FAR Council is working through. That list is growing and growing. It's about 12 pages long as of the 19th of this month, which is, 3 days ago. It has issues in it, including credit towards small business subcontracting plans for second-tier contractors, harmonizing SBA regulations with the FAR, provisions on paid sick leave, harmonizing provisions in connection with SBA and the FAR on limitations of subcontracting. Those things are indicative of just what I've described, where I think we're going to see, when the FAR Council moves through that process, a federal acquisition circular that really covers quite a bit. So let's keep moving forward. And I should say, because this particular presentation is dealing with a year in review, there's not a tremendous amount of sort of chronological or subject matter rhyme and reason, but the guiding principle is that these are all important. I have spoken to or with PNDC and some of you individually about cybersecurity requirements over the last year. So this is, for those of you who are there, this is not going to be new, but I just wanted to take a minute on it. We have 2 provisions, a DFARS provision and a FAR provision, that as of December 31st of last year required compliance of prime and subcontractors on the treatment of covered defense information, covered contractor information systems, and essentially cybersecurity and incident reporting. I would remind you to take a close look at your solicitation requirements. Hopefully, those of you who are subject to these provisions, where you see that particular clause or those clauses in your contract, now have system security plans in place. You have plans of action in place that will allow you to move forward quickly in the event of an incident. And you're also updating your prime, or you're updating your subcontracts to deal with the implications for subcontractor flowdown that are directly implicated by these particular clauses. You may also want to take a look at the memorandum that I have cited at the bottom here, which I had discussed significantly in that last presentation. This is a memo that the DoD had issued on the implementation of the DFARS clause, and it really gave some tremendous insight into how the DoD believes that contractors should comply. And I would just highlight, essentially, 2 points. One is that memorandum said it's the contractor's responsibility to determine whether and how and when it has implemented the necessary security requirements that are set forth in those clauses. And at the same time, it said that this is a performance-based clause, that contractors it's basically up to them to determine how to decide how to comply, and that there's not a single prescribed manner. So ultimately, there's not a tremendous amount of guidance on that, but it's nevertheless something that we need to, I would say, we review that memorandum, we review the clause, and we go forward taking this clause very seriously, because as we talked about last time, I think that's something that's going to be a subject of enforcement coming up. And I'm going to turn it over to Kate to talk about the NDAA.
Good morning, everyone. So as John mentioned, there have not been new developments in the FAR in the past year. However, looking at the National Defense Authorization Act for 2018, we have a preview of what changes that we can expect to be implemented in the immediate future. And this is a very lengthy document with quite a few changes identified, but I'm going to highlight the ones that are of most interest, I believe, to our audience here. So initially, Section 822 of the NDAA makes some significant changes to the Department of Defense use of low-price, technically acceptable procurements. Now, as you're all aware, I'm sure an LPTA differs from a best value procurement, and the government appears to be moving away from the use of LPTA. So this NDAA includes increased limitations, and it authorizes the use of LPTA procurements only where the Department of Defense would realize minimal innovation if an LPTA was not used, and if related to goods where the goods are predominantly expendable in nature, non-technical, or have a short shelf life. So they're really trying to limit the use of LPTAs to these two circumstances. And the provision also expressly prohibits the use of LPTA procurements in engineering and manufacturing contracts for major defense acquisition programs. Another change that we see coming, and this is significant for us Northwesterners, is that the government's trying to implement Amazon-like marketplaces for commercial products. This is set forth in Section 846 of the NDAA. And this is sort of a forward-thinking plan that we don't anticipate immediate changes, but the NDAA sets forth 3 phases to implementing these Amazon-like marketplaces. The first phase requires the OMB to create an implementation plan. The next phase requires recommendations to changes or exemptions from laws in order to facilitate the use of this commercial marketplace versus the GSA's current schedule requirements. And then the third phase requires creation of guidance for how the program will be used. That third phase isn't required to be implemented until 2 years after OMB creates their initial implementation plan. So our sense is that we won't see any concrete movement of this for the next 3 years. Nonetheless, it's something to be aware of as we're going forward and could have a significant impact on contractors. Third change is that the DoD is extending the the period of performance for service contracts up to 10 years plus 5 additional 1-year terms. So a pilot program is being implemented which could significantly change the term of contracts and allow for, on the one hand, longer term planning for contractors, but on the other hand, if you're not awarded one of these contracts, it is going to be a significant event and it may lead to additional protests since they guarantee such a long term of performance. The NDAA also increases the micro-purchase and simplified acquisition thresholds. So the micro-purchase threshold will be increased to $10,000 from $3,000. and the simplified acquisition threshold will be increased to $250,000. For those businesses that qualify as hub zones, the hub zone maps will be frozen through 2020, so that gives you some stability in terms of planning and knowing your eligibility for the next two years. Interestingly, for those of you that have come under the purview of the DCAA and their incurred cost audits, you're aware that there's quite a significant backlog to those incurred cost audits with, going back 10 plus years for some contractors. So the NDAA actually is taking DCAA to task a little bit on this and requiring that DCAA begin using private auditors. And this, they have some pretty strict and immediate deadlines for DCAA's compliance with this program. So by October 1st of this year, the Department of Defense and DCAA must produce a plan on how they will execute this directive and use private contractors, private auditors, to perform these incurred cost audits. And they must issue contracts to 2 private audit firms by April 1st of next year. The hope is that this will free up DOD and DCAA to take on the forward pricing analyses, which the DOD determines have more return on value for the government. And it looks like the long-term incurred cost audits will be covered more by the private auditors. Turning to some bid protest issues that are addressed in the NDAA, there's going to be significant changes to the post-award debriefing process, and we're pretty excited to see how this turns out and think that it will have a significant impact on how protests are used by contractors when they decide to file, and I think also on the success rates that we see in terms of contractors prevailing on their protest grounds. So there's a pilot program going forward that will apply to awards that exceed $100 million. For those awards, protesters and disappointed offerors will have the right to receive a redacted copy of the agency's written source selection award determination. They will also significantly have the right to ask follow-up questions within 2 days of receiving this post-award debriefing. And the agencies are required to provide written responses to these follow-up questions within 5 business days. And significantly, the NDA provides that the debriefing process will not be concluded until the agency delivers its written responses to these contractor questions. And the significance of that is that it extends the deadline for your CICA stay and allows contractors to really make an informed decision on when and what to protest. In addition to this pilot program for procurements that exceed $100 million, there is also a provision that says small businesses and non-traditional contractors are entitled to request and receive redacted source selection determinations for awards in excess of $10 million. So in effect, it'll have a pretty broad application, we believe. And finally, in an effort which appears to dissuade protests, there is another pilot program requiring contractors with revenue in excess of $250 million in the previous year to reimburse the DoD for costs incurred in processing covered protests in the event that the protest is unsuccessful and the GAO denies the protest in a written opinion. There's quite a lot of uncertainty in terms of what is included in this cost, and obviously if you're requiring, if this is implemented only when the GAO denies the protest in a written opinion, it allows contractors to move forward with the protest process and then try to reach an informal resolution or withdraw their protest in advance of a written opinion. This pilot program will apply to protests filed between October 1st, 2019 and September 30th, 2022. So it won't go into effect for a little bit, and it has a very limited duration during which we can assess the impact of this pilot program.
So turning to page 8, we're going to look at the pre-award environment. This presentation is basically divided pre and post-award, looking at some of the cases and developments Pre-award, I'd like to start with bid protest statistics that we have seen. These are, what you'll see on this slide, two reports that were issued within the last 2 months. One is a standard report that the GAO issues every year. This is their bid protest annual report. The other, interestingly, arose from the National Defense Authorization Act from last year, in which Congress commissioned a study into the bid protest process because Congress and the Department of Defense are of the belief that these protests may not necessarily be doing what they're supposed to do, which is protect the integrity of the procurement process, and instead they're really slowing down procurement. Unfortunately for those who thought they were going to get results that would support their particular position, what the RAND report, how they concluded was that protests generally, DoD protests generally, are exceedingly excessively small, that less than 0.3% of all procurements are ultimately protested. The other thing that's evident from these statistics, looking at the effectiveness rate up top, under the GAO bid protest annual report, and this statistic was more or less echoed in the RAND report, was that in about half the time, agencies, when they are protest, will take some form of corrective action. And that means that, contrary to what Congress and DoD thought, that there are certain issues that are being identified as a result of these protests and that the agencies are taking action. So the upshot of that is that the protest process and protest reform is, I think, going to continue looking at reducing flaws in the source selection process, which is a legitimate goal, instead of, for instance, discouraging protests, which I don't believe to be a legitimate goal. I mean, you're going to see, for instance, this coming year when you file at the GAO for the first time, that there is a filing fee of, I believe it's $300, and that's something where I don't think it's necessarily going to persuade the large significant protests, but as Kate will be talking about in a moment, it may dissuade some of those that are not let's just say particularly based on merit. And there are other efforts that I think we're all going to need to be aware of that Congress may take that are continuing attempts to dissuade or make it more difficult to protest. One of those is the increase, we should all be aware of this, is the increase in the threshold for task orders at the GAO, which in the 2017 NDA increased from 10 million to 25 million, which means that, if you have a protest on a task order under 24 million, you're basically out of luck. That was reconfirmed in a case in December of this year, where the GAO knocked out a protester on jurisdictional grounds because the task order amount, it was over 23 million, but nevertheless, it didn't meet some of the other exceptions that would have allowed GAO to consider this particular protest, which I think is obviously terribly unfair, considering that you have lots of IDIQs that can result in tremendous, high size complexity task orders.
So looking at some specific protests that we thought were interesting, relevant, in some cases slightly amusing. We'll begin with the GAO's decision in the protest of Latvian Connection. Those of you who have been in government contracting for a while may have heard of Latvian Connection. They are a business that makes a career essentially out of protesting at the GAO. So in the past 5 years, they filed over 300 protests with the GAO. They actually were suspended from protesting for a period of 1 year. That suspension was lifted earlier in 2017, and the decision we're discussing right now resulted in another 2-year suspension. So the GAO essentially found that this company was abusing the protest process by failing to comply with protest procedure and submitting filings that were incoherent and lacked legal and factual specificity. What I think is quite interesting about this decision is that in addition to finding that Latvian Connection abused the protest process, the GAO made the decision, and I don't think it was necessary for them to even reach this point, and yet they did, and that's significant, that the contractor lacked standing to protest. So what the GAO found was that this small business contractor had been protesting a huge array of contracts, ranging from repair of construction work, acquisition of sweepers, mobile incinerators, acquisition of modular buildings, vehicle leasing and maintenance contracts, and building renovations. And the GAO, apparently by looking at the contractor's website and other related materials, determined that the varied nature of the procurements protested, together with the lack of any evidence that Latvian Connection engages in such broad efforts, provides a reasonable basis to conclude that Latvian Connection is not an interested party to perform any of these contracts, and therefore lacked standing to protest. So the takeaway from that, and this may be unique to Latvian given their history of excessive protests, but for the GAO to find that you lack standing because perhaps you're trying to expand your contract repertoire outside of your core competencies is a pretty significant event and something that I think we should monitor in the coming year. The next case that we'll look at deals with the best value evaluation and the requirements that be documented and meaningful. This was a contract for a 3-year contract for corrugated containers. It was a fixed price contract, and Patriot Solutions was the disappointed bidder, protested the award. In this best value procurement, the solicitation and evaluation factors provided that technical and past performance ratings were far more significant than price. Here, Patriot Solutions had a past performance rating of more relevant, whereas the awardee had a rating of relevant. And the awardee had a better price by $160,000, which was pretty significant because the price offered by Patriot Solutions was about $830,000 and the awardee was about $650,000. Nonetheless, the GAO found that because the debriefing and evaluation documents described acceptable proposals and stated that price became the determining factor, the government had improperly converted this from a best value to an LPTA procurement. The government's position was that the use of this language was just typos and it was sloppy writing and it shouldn't be reflective of the actual analysis that the agency did in evaluating the proposals. Nonetheless, the GAO did not buy this argument, and they said that a best value trade-off analysis must explain why the higher rated proposal does not offer technical advantages. And when the agency treats all offers as acceptable, instead of addressing the comparative evaluation factors, they're converting it to an LPTA. A nice line at the end of this protest decision was that the GAO will resolve any doubts regarding prejudice in favor of a protester, since a reasonable possibility of prejudice is a sufficient basis to sustain the protest. So that can be useful going forward if you have potential prejudice and you decide to protest. The next bid protest that we'll look at was the statutory violations unrelated to the evaluation criteria stated in the solicitation. And this was a really interesting case. This was, the protester was L3 Unidyne, and they were protesting the award to Leidos on the basis that the awardee's employment contract contained mandatory arbitration clauses. Now, you may recall that in the 2010 National Defense Authorization Act, and this has been incorporated into continuing resolutions and subsequent NDAAs, mandatory arbitration clauses are banned from employment contracts for federal contracts that are in excess of $1 million. So if you are receiving a federal contract in excess of $1 million, you may not have a mandatory arbitration clause in your employment contracts. Here, the protester looked at the awardee's employment contracts and alleged that they were ineligible for award because some of their employment contracts did require execution of arbitration clauses. The GAO agreed with this and found that, in fact, the agency should not have awarded it to Leidos, and they were ineligible for award. Another interesting element of this protest was that the GAO found that informational deficiencies in the protester's proposal, so in L3's proposal, were insufficient to establish a material failure that would increase the risk of unsuccessful contract performance. Specifically, the solicitation required offerors to identify anyone who was working outside of the local community and demonstrate how those employees would be used effectively and efficiently, and also explain how the offeror would maintain effective management control over that employee who's working outside of the area. Now, admittedly, L3 failed to do this, and it was identified as a deficiency in its proposal. Nonetheless, even though the GAO acknowledged that L3 did not meet this solicitation requirement, the GAO said, given the totality of the circumstances, the agency has not explained how this deficiency is a material failure of the proposal that increases the risk of unsuccessful contract performance. So that really is a little foothold that contractors can use if there is perhaps a deviation from the solicitation requirements and evaluation factors. There might be a possibility of making an argument that while we deviated from the solicitation requirements, it's not reflective of significant risk in our proposal. Okay. Turning to the next protest, this also addresses Leidos, although it's a different contract. And here, Leidos was the incumbent contractor, and they protested based on the agency's decision not to award the contract to them, which they felt was based on an improper past performance rating. As the incumbent, Leidos felt that they were entitled to a rating of highly relevant past performance experience, which makes sense and is consistent with the solicitation criteria. However, in their proposal, Leidos included 7 contracts in their past performance history, so the incumbent contract as well as 6 others. And the agency, what they did was they averaged those contracts that had been identified, and based on the average of them, assessed a relevant rating rather than a highly relevant rating. The GAO found that that was proper and wasn't an abuse of discretion and dismissed the protest. So the message here is don't dilute your past performance history by unnecessarily including additional contracts that may not be as relevant as others that you have. The next case that we have is a little bit disheartening, but important to know about nonetheless. This was a protest by Level 3 Communications to the Court of Federal Claims. Level 3 Communications was an incumbent contractor. They protested the award. This was a LPTA evaluation, and they protested the government's award of this contract to Verizon. Now, not only was Level 3 the incumbent, but in this LPTA, their offer was $38 million less than Verizon's offer. So they felt that they should have been awarded the contract. While clarifications are permissive and were not required, here, one of the technical evaluation team members requested a clarification on a technical aspect of Level 3's proposal. The contracting officer did not seek this clarification from Level 3 and ultimately found Level 3 to not have a technically acceptable proposal. So let's talk about that initially. The Court of Federal Claims decision on that is great for contractors. Though they acknowledge that clarifications are permissive, here the court found that a CO's decision not to seek clarifications can constitute an abuse of discretion under certain circumstances like here where there's a $38 million price differential, and there's evidence that some of the technical evaluation team members thought clarifications could resolve this and lead to the award to level 3. Turning to the aspect of this case that's quite discouraging, in the Court of Federal Claims, you need to seek an injunction, unlike the GAO, where if you file within a certain time period, the performance of the contract is automatically enjoined. So here, level 3 sought an injunction, and the court held a hearing on this, and based on representations from the agency attorney, did not issue an injunction. The agency attorney represented to the court that performance would not commence, that the awardee would simply be engaging with subcontractors and preparing to perform, and that there would be no performance prior to December 1st. Well, it turns out, as the court learned in late November, that actually performance had been completed by Verizon. As you can imagine, the court was furious, and there's extensive briefing on the transcripts of the hearings, written submissions by the government attorney, and whether these were sanctionable events. Unfortunately, despite the government's lack of candor and the fact that the court was essentially precluded from issuing an injunction, which it may well have issued had the government been honest and forthright about what performance was occurring, there were essentially no repercussions for the government. So there were no sanctions. All the court concluded was that the government lawyer, the court would defer to the supervisor of the government lawyer who made the representation to determine whether there would be an adverse performance review in his annual evaluation. And that was the only repercussion to the government for this. And obviously level 3 wasn't able to get the award because the contract had already been performed.
Okay, so we have a few more pre-award cases to look at before we head into post-award. This next one, you recall that Kate had just mentioned that when you go to the GAO, if you file on time, you're entitled to an automatic stay or an injunction. This case addresses that, and it's a positive case, I'll tell you, but also at the top, with a note of caution, just bear in mind that we probably shouldn't follow this to the letter. So here, Favor Tech Consulting was a disappointed bidder. They received a notice of award on September 27, 2016. They filed their protest 10 days later. The agency had said, well, you know, the award was actually made on September 26th. And if you look at the Competition and Contracting Act language, which I've cited for you there, what it basically says, what it expressly says, is that you have to file within 10 days after the date of contract award, and what I read you is just a quote, or in the event of a debriefing, you're entitled to a debriefing that you'd have 5 days after the date of the debriefing. But for more, there wasn't a debrief in this case. So the key language that the court was looking at was, quote, 10 days after the date of contract award. And what the court decided in response to the government's position, saying essentially that the contractor, the protester had filed too late, was, well, you get from the date that you are notified, or I should say, to be more specifically, the date that the contractor knew or should have known of the award date. And if you look at that last hash mark, you can see the court's rationale. Without knowledge of the actual award date, potential bid protesters would be forced to guess how much of the 10-day period was remaining before filing a protest with the GAO and effectively would be deprived of their statutory right. The problem with this decision is that, in my view, it contradicts the plain language of the statute. And while it's fair, we can certainly anticipate situations in which, for instance, an agency does not tell the contractor that it's been that an award has been made, and perhaps in this particular solicitation you're not entitled to a debrief. Well, in that particular case, you'd be out of luck if the contract, if you were notified of that award too late. But this is a situation where the court doesn't get to make the rule; Congress makes the rule, and the way it stands right now, the statute says 10 days after the date of contract award. So what I would say is, if you find yourself in a position where you happen to be filing after the 10 days of the date of contract award, you can look at this case for some protection against a government argument that you're going to be filed too late. But I also think that you can count on that argument, and to the extent that you can, I would urge, if you're filing on your own or your attorneys, if you have protest counsel, to make the 10-day date, even if you're notified on day 2 or day 3 after the actual award, because you will avoid all of the potential problems that can arise from a late filing. The next case, Sancilio, is another bit of good news for contractors and protesters. Everyone, at least in negotiated procurements, should know FAR 15506, which basically says that if you are a disappointed bidder, you have 3 days to request a debriefing, and more or less, if you don't make that 3 days, then you're going to be out of luck with respect to the timing for the filing of your protest. In this particular case, Sancilio had asked for a debriefing 6 days after the date of the notification of contract award, and the VA honored it despite the fact that it was late. And after receiving that debriefing, they filed 10 days after they had the basis for their protest. The government came in and said, wait a second, just because we were kind enough to give you a debriefing late doesn't mean that we more or less waived the regulatory requirement that you request that debrief on time. And the court said, nope, agency, if you're going to go forward and give the protester a debriefing under the bid protest regulations, you have 10 days from the date that you knew or should have known, and under the CICA provision that we just discussed on the last slide, you have 5 days after the date of the debrief. So if you file your protest within 5 days after the date of a debriefing, even though you requested it too late, you can rely upon this case to ensure that you have something to say that you filed on time. I wouldn't count on it. I would obviously follow the regulation and request your debriefing on time, but to the extent that you're late, if you can coax information from the contracting officer that would give you a basis for a protest, it's probably a good strategy. Okay, the next case involves this is the Walker Development and Trading Group case. This case involves cancellations of solicitations and when they must be reasonable. This case involved an IDIQ contract for the VA for laundry services in hospitals in California. It was a lowest price, technically acceptable case, or solicitation, I'm sorry, and the VA canceled the solicitation initially upon receiving guidance to do so, and it extended the contract to the incumbent by the name of Railroad Cleaners under the FAR clause there, 52217-8. And Walker, who apparently had been trying to get in on this contract for some time, in their papers said, you know, it just seems to us that they win awards all the time and that this is essentially becoming a sole source contract. So at that point, the GAO asked the agency for the basis for the cancellation. And first they said, they offered multiple reasons for this. First they said, well, Walker would have won, but their offer was under the $1 million minimum threshold of the solicitation. Then they said, what their first answer was, we had received guidance and managerial direction indicating that the solicitation should be canceled. Then they said, well, we couldn't award it because the guaranteed minimum was $2.5 million. Then they said that there were significant errors in the solicitation and the VA had to take unilateral corrective action. Then the final thing that they offered, and there was extensive back and forth with the GAO, which both Kate and I have seen in prosecuting these protests. They said, the agency basically blamed Walker and said, well, they didn't request any discovery and it's just bare speculation that this brief delay is a pretext to circumvent competition and make a sole source to railroad. And at the end of all of that, the GAO said basically this record that the agency, this post hoc record that the agency is developing is not good enough. If you're going to cancel a solicitation, there needs to be a reasonable basis for doing so, and the agency report needs to reflect it. And here the GAO had concluded there was no coherent or rational explanation for that cancellation. So I should mention that the agency has very broad discretion in determining its program requirements. But if you do see something like this, it's certainly something where you should carry it forward and see if you can prevail. This next case involved the recovery of this is the protection strategies case from just a couple months ago. We don't see these cases very often because they involve the recovery of protest costs, and I thought it would be good for us all to remember, when that relatively infrequent occurrence takes place. Here, protection strategy had alleged that it had received and it should have received an outstanding rating, and that essentially that as documented in the agency report, the trade-off decision, this was the best value, had failed to justify the price premium. And the SEC had agreed at this point to take corrective action following a conference call with the CEO. So they basically said, the SEC said, we agree with you. At that point, the protester decided to pursue costs associated with what it deemed to be a clearly meritorious protest ground that never should have been brought in the first place. And this case, I just want to highlight the distinction that there's a difference between bringing a meritorious protest ground, which is one in which you win, which you don't necessarily get your costs, and one that is clearly meritorious. That's one where the GAO articulated there's not a close question, and where a reasonable agency inquiry into the protester's allegation would reveal facts showing the absence of and this is the important part, a defensible legal position. So here, there was absolutely no basis in the decision to justify paying that premium, and the protester was able to recover those costs. So keep that in mind. Last pre-award case I want to look at, this is the Blue Water Management case. This is an interesting case, particularly for those who do scheduled contracting. This was one where Blue Water had protested the issuance of a task order under an RFQ for lodging and transportation services. The awardee here did not have on its schedule contract one component, one CLIN that was required in the solicitation, and the RFQ had instructed that services must be on the vendor's current GSA schedule in order to prevail. Now, in response to this, and this is pretty clear contract language, the Navy nevertheless tried to get around it and say that, that CLIN was really just for ancillary services, and it didn't have to be on the awardee's schedule as other direct costs. The GAO said, no. If you, contracting officer, are going to put on your solicitation or your RFQ two independent CLINs, both of which need to be on a schedule, you're not going to be able to change that in order to make an award to a preferred provider or to go on a schedule and choose what you want. You can either structure your solicitation, your RFQ, so that everyone understands the ground rules, but you can't, after the fact, change those ground rules and deprive someone of what they're entitled to by awarding to a company that failed to meet a key solicitation requirement.
So now we're going to look at some post-award issues and cases that have come up, and I'll run through these next few ones a little bit quickly so that we can make it to our slides. But the first one I'd like to talk about is Asia Commerce Network. And this was a really interesting case because this was a contract to supply jet fuel to Bagram Airfield. And the contract provided that there was a 6-month period by which the contractor was required to achieve operational status and begin delivery. That 6-month period came and went. The contractor received a show cause notice, responded explaining the difficulties that they had encountered, Taliban attacks included, and essentially the government just let them continue to perform. There was no new definitive delivery date imposed, and the contractor continued to make progress, and there was documentation from the agency acknowledging the progress made. However, eventually, the fuel had not yet been delivered, and the agency moved to terminate for default. And the ASBCA said, no, you can't do that because you waived the delivery deadline that was in the contract, and no new delivery deadline has been imposed, so you have no basis to terminate for default based on a failure to meet the delivery deadline. So an interesting case in terms of if you do continue to perform after a deadline and the agency acquiesces to your performance. The next case we'll look at is KCON, Inc. And this case is just a reminder about the Christian Doctrine. The Christian Doctrine provides that if there is a clause that is mandatory and represents a significant public procurement policy, it is included in your contract whether you see it there or not. So KCON was awarded a construction contract. The contract did not provide that they were required to get payment and performance bonds. Once they were awarded the contract, they learned that the government wanted these payment and performance bonds, and that resulted in a 2-year delay in the issuance of the notice to proceed and their performance. And they filed a claim for the costs associated with that delay, and the board held that they weren't entitled to those increased costs because they should have known under the Christian Doctrine that these bonds would be a required element of performance. The next case is alarming on many levels. This is Magnus Pacific Corp versus the United States. Here there was a contract for levee restoration work in Texas. The contractor incurred significant cost overruns as a result of extremely poor designs provided by the government. And it turns out that the government engineer who drew up the designs was cognitively impaired. So cognitively impaired, in fact, that the government asked for him not to testify at the trial because it would be a hardship due to his cognitive impairment. So not only, it was sort of incongruous. They stood by his design and said the contractor wasn't entitled to increased costs. Nonetheless, he was so cognitively impaired that he couldn't testify. The court noted that there had been a video deposition of this engineer, and they said after review of all the portions of the deposition that we were presented with, the court concludes that the design was severely affected by his lack of experience and restoration, as well as by the cognitive difficulties he was suffering from his brain injury. So I think we're all glad we don't live by that levee, and hopefully they were able to finish it with better design.
Okay, the Perry Barch case, which is on slide number 23. I feel like I do one of these every year that we do this presentation on releases, and this is the release case as a reminder. Please be careful when you sign these releases. Even though on this case the contractor was lucky. This case involved a renovation of a visitor center complex at Mammoth Cave National Park in Kentucky, and over the course of the performance, the contractor and the agency issued a number of modifications in which there were reservations in the release language signed by the bilateral modifications, and there were reservations by the contractor as to time impact that they intended to carry forward. Then they decided to execute a global modification. This was modification number 14, in which there's language, I won't read it to you, but it contains the forever discharges the United States from everything and everything you could possibly think of without there being any particular reservation. And the record, it appeared as though the contractor and the government kind of knew that this particular Mod 14 wasn't intended to cover all of the time impacts that had been reserved in the prior modifications, but for the life of me, I don't understand why they didn't include it. Nevertheless, the government took this opportunity to make an argument that the release on Mod 14 was unambiguous and it precluded all of the contractor's claims. So they took the initiative in the litigation and moved for summary judgment. Thankfully, what happened for the contractor was the court concluded that there were ambiguities in the release and went outside of the language to look at the parole evidence. They essentially looked at the negotiations and the other evidence that preceded and even afterwards, after the release, to look at what the parties intended. The government's motion for summary judgment was denied, but this is a cautionary, it's a positive tale, but it's a cautionary one. Here, Perry Barge got lucky, I would say. Whenever you are negotiating releases, particularly when the government says something like global, be sure you have appropriate language in there reserving your rights. Otherwise, you could be in a position that is not as fortunate as the contractor was here. I also tend to include in these year-end regulatory and review presentations a good faith and fair dealing case. This is one from April of this year that puts an interesting spin on good faith and fair dealing. Any contractor who's tried to prevail on asserting a breach against the government for the implied duty of good faith and fair dealing and the duty of cooperation will know that it's an exceedingly high standard of well-nigh irrefragable proof. In this particular case, it involved delivery through the use of trucks, some of which were refrigerated, some of which were not. But for here, refrigerated trucks for food and medicine in various bases throughout the Middle East, and the government was to be compensated on rates that had been identified in the contractor's proposal and in the contract. One of the limitations was when the trucks arrived at these particular bases for drop off, even though a base or a location may not have refrigeration, that the installation would not use the truck as a refrigerator, and this is essentially what these installations did. And as a consequence, the government ended up paying vastly higher, significant sums for the delivery because they were using these trucks as refrigerated storage units. The contracting officer became upset about this and basically went back to the contractor and said, we want to impose a cap of no more than 29 days for any route that you may be driving. And the contractor, again, reluctantly agreed to this on the premise that, okay, well, if we take an exception to you using our trucks as refrigerators, we'll just consider that in the form of a claim. And more than that, they went ahead and extended the contract on the same premise that, okay, just submit an alternative proposal based on actual cost data. That's what the CO said, and we'll take a look at it. So unsurprisingly, the contractor here submitted a claim beyond the 29-day cap, and the CO said, "Hey, we negotiated this. You agreed to it, and we're denying your claim." And the board on the substance agreed with the CO, and contractor loses. They go up to the Federal Circuit. Similarly, on the substance of the actual claims, on the negotiation, the contractor loses, but the Federal Circuit says, if the government impairs your ability, it acts in a way that makes it essentially impossible for you to do what you want to do, to perform in the way that you had anticipated, which here was not to use these trucks as refrigerators. Well, that's a breach of the duty of good faith and fair dealing. So it's a very interesting spin here, in even allowing the contractor to get around language that it negotiated that should have been, in my view, kind of a death knell here. But something to keep in mind and a spark of hope in these good faith and fair dealing cases. 4 more slides, and we're there.
So we're going to talk briefly about updates to the False Claims Act. You may recall in the 2015 case Escobar, in which the Supreme Court rejected the government's, quote, extraordinarily expansive view of False Claims Act liability. Now, essentially, in that decision, the court held that for an implied certification being when a contractor submits a claim to the government, they impliedly certify compliance with all conditions of payment. So the Escobar decision held that, yes, you can have an implied certification as the basis of liability, but in order to find liability, the false certification must make specific representations and be material to the government's decision to pay. So the court was clear that this is not an all-purpose anti-fraud statute, nor is it the proper basis for bringing a garden variety breach of contract claim. And now what's required for a viable False Claims Act under Escobar is that four things. One, there has to be a false certification or statement of compliance with a government requirement for payment. That certification has to be made with knowledge of the falsity and knowledge that compliance is material to the government's decision to pay. And then the claim has to seek payment from government funds. So this has been a great case for contractors, and what we've seen since it came down is that courts are rejecting False Claims Act liability where it otherwise may have been found under this implied certification theory. The most recent development was a case that the decision came down just 10 days ago, I believe, and this was out of Florida. There had been a relator brought a claim for False Claims Act violation relating to a medical facility on the basis that the facility failed to maintain a comprehensive care plan which was required by Medicaid regulations. And the failure to provide this care plan and submit billings to the government constituted false claims. There was a jury trial. The jury awarded about $114 million to the relator, finding that there had been false claims against the contractor. Then, due to the treble damages, the court turned that into a $350 million verdict against the contractor. What this recent decision from 10 days ago did was overturn that jury verdict and found that, in fact, there was no meaningful and competent proof that presented at trial that the government would have regarded the disputed practices as material to the decision to pay. So even though, yeah, it's true that maybe they didn't have this comprehensive care plan in place, that was not necessarily material to the government's decision to pay the invoices, and therefore there could not have been false claims liability. Significantly, the court also found that the relator failed to prove that the defendant submitted claims for payment despite the defendants knowing that the government would refuse to pay the claims if the government had known about the disputed practices. So not only does the knowledge requirement have to do with the falsity of your submission, but you have to know that the government will rely on your misrepresentation in their decision to pay, which is an extremely hard thing to prove, I would think. So I think that this will continue to be a beneficial line of cases for contractors.
So this next slide doesn't deal with a case, but in December of just last month, the National Veteran Small Business Engagement Conference took place in St. Louis, and there was a panel, a VA panel, who was there that included the Executive Director of Small and Veteran Business Programs, the Deputy Assistant Secretary for Acquisition, and the Chief Counsel. And at that seminar, that meeting, the VA introduced the concept of tiered evaluation. Now, for those of you who are familiar with the Kingdomware decision, and that case goes back, it goes back to 2011. Frankly, if you consider the cases that preceded it, there was a challenge to the VA's application of the rule of two, and the outcome of Kingdomware was that the VA, when it was acquiring goods and services, even on a federal supply schedule, had to abide by the rule of two, which means that if the contracting officer had a reasonable expectation that two or more small businesses would submit offers and awards would be made at fair and reasonable prices that offered best value to the U.S., that it would be set aside. The Supreme Court in Kingdomware had determined that the VA, after a variety of different arguments, was not applying its own statute, the VA Act, as well as regulations requiring the rule of two. So this was obviously a very, very good thing for VA procurements. Nevertheless, the VA remains concerned that it's paying excessive prices to award to veteran-owned companies. And what we heard at this particular seminar was that the concept of tiered evaluation would envision a solicitation that's set aside for SDVOSBs and VOSBs, but that large companies would also be allowed to submit offers. And if the VA determined that it wasn't receiving fair, reasonable prices at that first tier, which would presumably be SDVOSB. It would then go to the next tier, which would be veteran-owned small business, and then it would go to the next tier, which would presumably be something like all businesses. And I think the collective takeaway from that was, well, how are these COs going to be determining fair and reasonable pricing? Just because a service-disabled veteran-owned small business determines pricing that's higher than a large business, that doesn't necessarily mean that it's unreasonable. So I think for all of us, as these particular VA solicitations come out, let's take a close look at them and be sure that we're getting a fair evaluation. And if you do see something suggesting tiered evaluation, be very, very careful in ensuring that your rights are protected. Okay, our one small business case, because we have a number of small businesses in our audience and our membership, is the Yardmasters case. This is a case where, very briefly, Yardmasters had been awarded a contract, had been protested, and as is very typical, the SBA area office decided to ask some questions of Yardmaster regarding the nature of the women-owned small business. And in this particular case, the offer that was submitted by Yardmasters was submitted on the 30th. 4 days beforehand, the company, the husband, Bryce, had there was some documentation of this. The husband, Bryce, had paid his wife, Sally, $100 for 1% of the stock, which shifted the ownership to 51 to 49%. This was evidenced in share certificate purchase contract that was executed 1 day before the offer went in. And the tax returns for 2014 through 2016 had shown no compensation for Sally, but all compensation for Bryce. And the area office said, well, this looks like a sham contract or a sham setup for us. We're going to sustain the size protest with respect to both ownership on paper and control, ultimately concluding that this is really Bryce's company and not Sally's company. OHA, when it was appealed up to the Office of Hearing and Appeals, they concluded that, well, we understand that a stock transaction can take place if it's for $100 as a matter of cash, and there might not be anything, on paper the way that the area office wants it. But as far as control is concerned, they made a number of specific findings saying that, for instance, Sally was the chief executive officer, but the board of this company never created a CEO position. The bylaws stated that the president is the chief administrative and executive officer, and that was the position occupied by Bryce. And this is particularly bold, that basically in connection with the proposal, in connection with the protest, you would think that Sally would step up and sort of take the helm at that point, defending her own company. Bryce was doing all of that. So at the end of this, OHA said, yeah, we agree with you on ownership, but when it comes to control, Sally, you need to demonstrate a little bit more actual control, at least up front. Give us something to hang our hat on. She had said, you're doing this because I'm a married woman. I'm just married to Bryce. And OHA summarily dismissed that. So if you happen to be, a husband-wife team and you're a women-owned small business, be sure that you have both ownership and control well documented.
And finally, a little bit about continuing on the small business front, the VA and SBA Small Disadvantaged Veteran-Owned Small Business Guidelines. Now, historically, the VA has had its own SDVOSB guidelines for VA procurements, and then the SBA has its own SDVOSB guidelines for more general government procurements. In 2017 NDAA, they directed that actually the SBA should have control over all these guidelines. And so in a rule published about 10 days ago on January 10th, the VA is noting that its regulations relating to and clarifying ownership and control are no longer the responsibility of the VA, and they will direct contractors to the SBA's requirements, which are found in 13 CFR Part 125. Now, the impact of this remains to be seen. Yes, it will make things more streamlined for small disadvantaged veteran, service disabled veteran-owned small businesses. but the SBA's guidelines are a little bit stricter than the VA's, and in a recent decision, they were called draconian and perverse by the Court of Federal Claims. And this is the Veterans Contracting Group versus United States. And this was a 2017 case where a service-disabled veteran owned 51% of Veterans Contracting Group. And there was a provision in the bylaws which stated that the entity, the Veterans Contracting Group, could buy the owner, Mr. Montano's, shares upon his death. And the SBA determined that because the entity could buy Mr. Montano's shares and the entity was 49% owned by somebody who was not a service-disabled veteran, it deprived Mr. Montero of the full value of his ownership interest and was a significant restriction on his exercise of unconditional control. This was appealed to OHA, who agreed, and the Court of Federal Claims upheld this determination. So, the irony here is that there was no claim that while he was alive, his ownership and control was at all impaired. What happened was, upon his death, he might not be able to control his entity, but nonetheless, under the SBA rules, the Court of Federal Claims, OHA, and the SBA all found that he did not have sufficient control to qualify as an SDVOSB under the SBA's guidelines. So a little warning there regarding structuring of your SDVOSB and perhaps insight onto what we'll see now that we'll all be subject to the SBA's guidelines on SDVOSB eligibility.
So with that, I just wanted to, Kate and I both wanted to say thank you. This year turned out to be a little bit different than years in past because we didn't have, extensive any FAR, DFAR updates, but I think what we did see in these cases is a number of interesting affirmations and changes on the existing regulations that are there, and hopefully when we speak with one another again next year or over the course of this year, I suspect that we're going to be seeing some very significant changes in these regulations. And to Kate, Canifo, and PNDC, thank you very much for having us.
Thank you.
Thank you, Kate and John. We really appreciate you lending your expertise to this program, this annual program. Great information. If you do have a few minutes to stay on the line, I'm going to ask the audience if they do have any questions. Again, they can type that in the question field, and we can get those. Yeah, wonderful. Thank you. As a reminder, we are recording this presentation and we'll send out a recording to everyone after the event. So if you want to share this with any of your colleagues, you can also, under the Handout tab, download a copy of this presentation. Some very valuable information that I'm sure everybody will want to use. John, I know you referenced this earlier. Maybe we can start off the questions while people have time to type here. Looks like the government is still shut down as of now, but I think the Senate passed it and it's going to the House. Don't quote me on that, but any comments on how the continuing resolutions or this shutdown are affecting government contracting?
Yeah, this is something that as soon as the shutdown happened, on Friday, I think all government contracts attorneys began, thinking about how to counsel their clients with respect to, how to successfully navigate the shutdown to protect themselves. I mean, the key here is that there will be consequences from the fact that, contracting officials, contract administration officials will not be there. Because these individuals, in a great many cases, will be occupying non-accepted services. So it will be important for you to review your contracts, review the schedule requirements, review the payment information, review your performance obligations, call your contracting officer, and see what, if any, impact is going to arise. There are notifications consistent with the labor regulations with respect to your subcontractors that you're going to need to even if this continues for a few more days, if there's an impact, that notification, look in your contract and subcontracts and be sure that you are abiding by those particular notifications. You're also going to want, and this is a point not only for shutdowns, but for any significant impact. You want to be sure that you're making a record of your particular time, delay, and cost impacts arising from the shutdown, to the extent that you have to, create a separate cost code. These are the sorts of things that, after the fact will make it far easier to prove your entitlement to money and or time as a consequence of the shutdown. And then I'd finally say, be sure that you are complying with your normal deadlines. Just because the government is shut down doesn't mean that you're excused, which I circle back to the comment I just made. Call the CO, assuming they're there, or a rep, and get someone on the line who can tell you exactly what the impact is and what the changes are going to be, so that hopefully you'd be able to negotiate on the front end a modification that will increase your contract price and extend your time.
Great. Thank you so much. Really appreciate your expertise. I do have a few reminders for our audience. In addition to a copy of today's presentation under the Handouts tab, we do have a list of upcoming PNDC events. A few that I did want to point out: we will have 2 Homeland Security Innovation Summits. This will bring some procurement officers from Department of Homeland Security directly out to the Pacific Northwest on February 7th in Portland and February 8th in Seattle. We will also have a roundtable with U.S. Congresswoman Suzanne Bonamici on February 20th in Portland, and a networking event at Tactical Tailor on February 27th in Lakewood, Washington. Thank you again, Kate Kennedy, Jonathan DeMella. We really appreciate you sharing all this information with us here today. Very helpful to kick off the new year. And we will conclude the webinar now. Thank you again for everybody joining us here today.
Thank you.